Ladies and gentlemen, Daniel Forouzan, host of the Schmoozin with Forouzan podcast. If I'm a little loud today, it's because I'm really excited. This is going to be a unique podcast. This is the first time I've ever done one without an outline. I didn't create an outline because I don't think I need an outline, because my guest is Khail Parris. Well, what's the big deal with that besides the $120+ million verdict he recently just got? I have actually known his father for quite some time. And I'd like to start by telling a story just for a minute, and then we'll go to the guests of honor here. I met Khail's father, Rex, at Loyola Law School, where he did a seminar. And in that seminar, he blew my mind based on his understanding of psychology, body language, social influence, and things of that nature. I actually ended up going to dinner with Mr. Parris that evening and with my professor, which is weird, but whatever, I was there. And I kind of kept up with his career over the years. A few months ago, I was fortunate enough to have Rex Parris on this podcast. And he was talking about the same stuff he was talking about from 10, 15 years ago at Loyola Law School. And I love that because the fact that he's continuing to do it implies to me that it works very well. One of the things he said in his podcast was, I've been teaching my children this from when they were young. The very next week, Mr. Khail Parris goes and hits a $120 million verdict. Clearly, there's something good in the Parris household. There's clearly something good in the water there. I am here to pick his brain for everyone's indulgence. I am so excited about this. Khail, thank you so much for coming on, my man.
Hey, thanks for having me. I'm super excited. I feel definitely blessed, and I don't know. This is exciting for me.
What's it like to have a big time trial lawyer as a dad?
It's super cool. I know a lot of people seem to think like it would be. I always get told, "Do you feel like you're always in a shadow?" I've never really felt that way in a negative way. I've always felt of it as a positive thing. But it's a lot of fun. It really is, especially now that we're trying cases together pretty regularly. A lot of fun. Especially when you have a trial attorney for a father who's actually a good trial attorney.
Yeah, I bet. I remember when I went to meet him one time in Lancaster, like I went to Subway that morning for breakfast, breakfast of champions. And everyone there knew him. Obviously, he was also the mayor of the city, but everyone there knew him, and everyone had nothing but positive things to say about him. And everyone seemed obsessed with like an Audi or something that he had back then. Was that what it was? Is it an Audi?
Yep, you got the R8.
Yes. Okay. And then I met the man and I understood all of it. I met him before that, but the presence, the demeanor and everything. And then when I interviewed him on the podcast and he was talking about how he's been training you since you were young, I thought that was very interesting.
Yeah, no, absolutely. I mean, I was the youngest at most seminars growing up. I almost got NLP certified at like the age of like 15. For those who don't know, it's neuro-linguistic programming. It was kind of our childhood, which was cool. I enjoyed it. It was awkward at times, but it was definitely enjoyable.
Did you end up getting NLP certified?
I didn't. And there's a funny story behind that. And I don't know if my dad would be happy with me telling you. I'll go ahead and do it anyways. I'm sure it'll be okay. I was like 1 or 2 away from it, and he was 1 or 2 away from it as well. But he wound up getting kicked out of it because he disagreed with some of the teachers on it in a big way. And if you've met my dad, nicest person, but he's at times when he feels he's right, he's not going to shy away from that. And so when he got kicked out, I wasn't going to go back, there was a loyalty factor there, but no, I never got certified, but I still learned a lot in the process.
Do you think it's worth getting certified? Or let me change that. Let me change the question. Do you think it's worth going as far as to maybe get certified or get close to certified? Do you think that's a good indoctrination?
I think I don't really care about certifications. Certifications are just a piece of paper. I think it's always worth it to explore and see what use those types of techniques will have. I think everything has a time and a place, and the more tools you have available to you, the better off you're going to be in any scenario.
Well said. Let me ask you, could you give, just because the audience is going to be like, what's neuro-linguistic? What? Can you give just a brief example, or how would you explain it to someone who's never heard of it?
Sure. So neurolinguistic programming is all about the use of nonverbal communication and its effect on somebody else. And there's a lot of varying branches that go off with that. If you were to Google YouTube videos, there's a lot of people on how they can essentially dupe somebody into giving them their house keys or their car keys just by either overloading their brain with certain stimulus or by utilizing things that are called mirror cells, where essentially I adopted particular posture or a particular tone in order to evoke a certain response in the opposite side. I mean, it's a very fascinating science. I think sometimes it goes too far, but I think everybody should learn that for themselves. Where is too far?
Well, let's talk about that too far. You say to people, hey, you can dupe someone into giving you their car keys, and someone listening who's never heard of neurolinguistic programming, or maybe people who even have, say, really, it sounds a little iffy. Could you maybe tell me what you think when you say it can go a little too far?
Sure. So, I mean, the one that he got kicked out of, they were teaching that neurolinguistic programming can cure cancer. You can understand why he got kicked out when was the first one to be like, you guys are crazy. And some people take it too far. Some people take it too far in the sense that they think that it can always dupe somebody into giving you their car keys. That's not the case. I mean, it is a means of providing a trained method of providing stimulus to a particular person in evoking a hopeful response.
That's a very good way to put it. I have done a little bit of dabbling in NLP. I think sometimes people come across certain tools, maybe through just hearing other people doing it, let alone going to courses and stuff like that. I always find it so interesting, so entertaining. And there's the whole notion of interactions with people with nonverbals or subtle gestures or subtle communications. That whole dynamic is so fascinating to me. Let me ask you, I'm going to tell you right now, I'm straight up jealous if you were getting trained in this stuff from your childhood. Absolutely straight up jealous. But tell us, what was it, your father spoke about these reversals and he was training you on reversals. What was that like? What was that all about?
It was funny most of the time, to be honest with you, because it was, we'd be watching like The Lion King. And he'd be like, yeah, exactly. And he'd be like, did you see the reversal there? And we always used to do this because this was his hand gesture for it. Like, did you see the reversal? And so it was kind of a joke. And we were doing it as a joke, not realizing we were actually learning a lot in the process. But anytime we'd go to a movie that he was really interested in, we'd stop and be like, did you see that reversal? Did you see it? But it wound up, it was interesting how much you absorb as a kid, not realizing the value of it later on. So then, we'd be at school and we'd sort of be able to see why certain things were interesting, or how to make our own stories more interesting, or how to persuade our teachers to not get us in trouble, not do certain things, not send us to the principal. So it was interesting. And my parents were always very supportive of utilizing these tools. They had a rule when we went to school that if we could talk our way out of trouble, they would not punish us, even if we did the wrong thing. So like if we got caught cheating, for example, something somewhat small when you're young, if we got caught cheating and we were able to utilize the tools that they had given us in persuading people and talked our way out of it in an ethical way, obviously, we would not face any repercussions when we got home.
Could you give the audience an idea of what a reversal is?
Yeah, so it's kind of it's hard to explain from my perspective because it's kind of like I can just see it, But a reversal it's sort of a reversal of the expectation, and it's the punchline of pretty much every joke is a reversal on your expectation, or a reversal is when the Lion King example, the good one was essentially when which one did we use? It was essentially when Mufasa would die by Scar. There was a reversal. I forget the line that they said, but there's a reversal there where you have an expectation as to what's actually going to be said, and then they reverse it on you. and it piques your interest, it piques your curiosity, and it draws you in.
How does that tie into trial?
Well, I mean, it's more important today than it ever has been, because tying into that idea that reversals pique your curiosity and they draw you in, we now are in a scenario or in an age where everybody is looking for some sort of gratification and instant gratification from whatever they're watching or doing. And so when you can create reversals in trials and you're the protagonist in these reversals, it draws the jury to you. It draws the jury towards your case. And so a lot of times we're trying to set up reversals within the case. A common one that my dad uses a lot is the lottery ticket one. I'm sure people have probably heard of it, but I'll kind of give a brief summary of it. We try to get the defense attorneys to say, these ridiculous numbers, these tens of millions of dollars, this is winning the lottery. And the reversal on that is essentially you take their metaphor, so to speak, of the lottery and you flip it on it. And it's essentially, it goes like this. It says, here's the lottery ticket. It's tens of millions of dollars. It's the Powerball, Super Lotto, whatever. And here it is. You can have it. You can take it. But if you're going to take it, you got to take a couple of other things too. You're never going to walk again. You're never going to hold your wife again. You're never going to wake up with a single day where you get out of bed and that pain is gone. You will always have pain. You will always have some sort of just cloud over you. But it's the $80 million. Don't you want it? And that's kind of the idea. You take a simple concept and you reverse it on its head.
Very interesting. Every time I hear that, it's still enlightening. And I think it's extremely enlightening for the audience. It brings me to a place where, I play piano. I write music on the piano. And one of the things I notice when I write music is I'm not a pianist by my profession. What I can play on the piano is effectively what I learned in my teenage years, and I stopped, and now I just write my own based on that skill set. As a result of lacking, for example, some knowledge of different chords and different harmonies on the piano, I have to come up with other ways to keep the audience's attention. Mm-hmm. And you might even notice as I talk, I start talking really fast and then I slow down. It reminds me of writing music. It reminds me of the music is going in one direction. All of a sudden it goes in the other. The music is building up and then it comes down, and it builds up and it comes down, and it builds up. And then the third time it explodes or whatever it might be. But you're building that tension, maintaining the audience's bandwidth, so to speak. Am I at all on the right track here, or is this something?
No, you absolutely are. I mean, that's dead on. You can have there's a lot of different ways in which reversals manifest themselves. It's not just the expectation. It's also, like you talked about, with your voice and your tone. And obviously you have a great following, so the way in which you present is working. And you clearly have studied it, but no, that's absolutely right.
If I said to you, solo PI attorney, 5 years in, is listening to this podcast right now, and they're saying, what is reversal? What would you say if you said, hey, do this one thing right now, or read this one thing, or watch this one, whatever? What's the one thing they should do, in your opinion?
If they're 5 years out, I mean, other than, it's kind of a tough question, because normally I would say you need to read this book. You need to do this thing. But just as a global perspective, I think the one thing that you need to do is try a case. And when you try that case, you need to do it willing to have everyone laugh at you and be okay with it. Be willing to say the things that seem scary to you and be okay with the fact that people might laugh at you. When we did that $120 million case, everybody thought we were out of our minds for asking for that much. And at times it was tough. It was tough. You'd have these jurors that would just pummel you over it. Just say you're. I think one juror said, it's offensive how greedy lawyers are.
Oh,
which hurts, you try to bottle that away, but it hurts. But you have to be able to bear that stuff if you're going to be able to push yourself to new boundaries and new limits and get better results at the end of the day.
Interesting. When you said there was a book, what would be the one book?
My favorite book is Never Split the Difference.
Okay.
It's a FBI negotiator, Chris Voss. And it just has a lot of tools that I use most often day to day.
Interesting.
And it's not, I mean, it is about negotiating, but it's not just about negotiating. I mean, it's valuable tools for how you can extract information, how you can get people to talk to you and tell you more. And I find that in my day-to-day practice, I use that the most.
It's an interesting thing. I think part of the reason I came upon these studies was I never felt like I was a great communicator. I was very shy when I was younger. And someone says, "Oh, Daniel, you're reading all this stuff. This stuff, is it you lawyers? Are you manipulating us?" And this and that. I mean, no, I don't know if that's the right way to look at it. I do think it's nice to be able to communicate with people. Take it from someone who wasn't very good at communicating when he was younger. It's nice to be able to connect. It's nice, and you're again. I don't mean to make this podcast is about you, not your dad. I apologize for consistently bringing him up, but I remember when I walked out of your father's office, he came over and he said, "Hey, please stay in touch." And he reached out and he squeezed my shoulder twice. I remember still. It's good to be able to make that connection, if nothing else, just for the wholesome joy of being a socially connected species. So I appreciate, someone says, "Oh, why is he reading a book on negotiations from an FBI guy getting in front of a jury?" I think you should read a book on FBI negotiations even when you're dealing with your parents. Are you kidding me?
Even dealing with your wife,
Yeah.
even dealing with your significant other.
Yeah.
I mean, just reading that book improved my relationships tenfold, because she felt as though I was actually listening to her. And it was crazy how much it changed. But I mean, we won't go too much into that if you don't want to, but I don't think everybody wants to hear about my personal life in that way.
I bet you there are some people who are curious, to be honest with you. I mean, look, your law firm is doing some crazy numbers in the regular. You guys are obviously involved in all sorts of stuff, whether it's politics or business, and it's a very impressive resume. But the conversation will go where it goes. Let's check out that $120 million verdict. What was that case all about?
Sure. So it was a T-bone collision. Essentially, my client was coming home on Valentine's Day, and he was driving his truck, and a girl who was, I think she was 19 at the time, she was on her phone, and she essentially blew through a stop sign. And so she T-boned him. It was a two-way stop, and it caused his truck to roll several times. And it was kind of a case that the insurance company wrote off pretty early on. And we got brought in on the case after it didn't settle at their first mediation. And mind you, I mean, they were willing to take, I think, like $95,000 at that time. And just because the insurance company was it was kind of disgusting what they were doing. And so then when we came in, we sort of just prepped it as best we could. And our client ultimately we got the brain imaging studies back, and it explained a lot of the weird things that we saw within the notes of the file, just kind of how our client would behave. And he had a brain injury, and he had herniated discs up and down his spine that he'd gone unaddressed. And so we were able to help him out on that, and it turned out well at the end of the day.
When you say brain injuries, the world of TBI, it can be a lot. It can be, as mild as a concussion. Concussion arguably isn't mild to begin with. I could imagine an adjuster would disagree with me on that. Can you give us, we don't have to get into the specifics. I don't want to get into the specifics of your clients, but when you say the neurological examinations revealed things, generally speaking, what are you looking for in neurological examinations?
So I used to look at like a doctor's neurological examination, but I started to move away from that. And I generally rely on my own conversations with the individual. And it's just one of those things where I've had enough cases where at the last minute we got an MRI of the brain and it showed something. And it was like, oh, that explains why he was acting, just mannerisms that I thought would be weird. Like, for example, if you ask your client a question and it feels like they're just talking in circles, or they just talk towards things that are completely unrelated to the question, or they dominate the conversation by doing that, there's a good chance you might have a frontal lobe injury there. And that's just something that I've picked up over time. And so now that is my biggest tool that I use, is I always have an interview with them to try to just feel it out. I look for the loss of consciousness stuff like everybody else does as a general initial guide. And I generally look at the type of the collision. I mean, if you've got a 5 mile per hour fender bender, you probably don't have a brain injury. As much as you may want to claim one, you probably don't.
There are certain PI attorneys who would disagree, obviously.
I know. Well, no, it's true. And I do that from time to time too. But I mean, there are certain things you've got to look at and say, okay, is this real? Is it not real? But yeah, I think talking with the client is the number one thing that I rely on these days. If you don't have your own sort of like radar for that type of stuff, usually it's the family members. Talking to the family members. Is he different? Is she different? Are there certain things that seem weird now? And most of the time they won't report it until you specifically ask. And you have to go through specific ones. Does he seem like he snaps? Just he's a lot less patient with you. Does he seem like those types of things? Does he seems like he just doesn't even listen to you? That's a big one. Yeah, that's what I would recommend other people to look for if you don't have that internal radar.
Understood. So your poor clients get T-boned. Their vehicle rolls. You detect something, neurological deficit or something is not quite right, and herniated disc, I'm assuming all sorts of spinal injuries and all this stuff. What you came in after mediation, right?
Yeah. After the complaint was filed, initial discovery was done, and then an early lit mediation.
Okay. What were your, I don't mean to dip into the special sauce, and you can speak generally, but what was, it's just a big verdict, so of course everyone's going to want to know. What was your initial take on the case?
If I'm being honest with you, I undervalued it initially. If we're being completely candid, the biggest reason that I wanted to bring the case in was because the person who referred it in was a friend of mine from law school. And I really just wanted to try a case with her. And then when I saw the collision photos, I thought, this could be a pretty good thing. And then from there, as we just started to work it up, it got bigger and bigger and bigger. But no, personally, I undervalued it in the beginning for my own selfish reasons. Thankfully, I corrected that as we were going on, but initially that was probably my mistake, if I was being candid.
And is when you say you corrected that, and I appreciate the candor, and trust me, so does the audience. These are learning experiences.
Yeah.
I think predominantly for myself, just because I have the luxury of asking the questions, but the people who do watch say, Daniel, you're going to get us MCLE credit for these things, which by the way, I'm working on, but it's not, there's not a lot of like podcast MCLE out there. And because these are not outlined, there's issues with getting MCLE, but I'm working on it. But the audience appreciates it because much of the audience is like myself, people who are interested, who are listening to a podcast in their free time on this topic because they have an inclination towards this stuff to begin with. So it's so interesting to me hear how this thing carried out. And you said you course corrected a bit. The course correction, was that based on your conversations with the client where you began to notice some stuff going on?
Yeah, so the course correction was twofold. One, it was based on the conversations with the client and his wife. I had them both where I sat down with both of them. And that was the biggest course correction when it came to the brain injury. When it came to the spine, it was talking with him and also talking with his treating physician, his spine surgeon. He hadn't had the surgery by the time we had come in for the lumbar spine. But what originally it was brought in as just a lumbar spine case. And so we only kind of evaluated that initially. And then when I started talking to him, he was like, no, it's my neck and my lower back. I just, the lower back is the primary issue, but my neck kills me all the time. And my hands are numb and all the telltale symptoms. And then when I talked to his treating doctor said, he never told me that, but he does have serious issues with the lower back. And so then when the client was able to go to the next appointment with the treating physician, I was able to talk to the treating physician both before and after. And that's when everything came to light. That's when we realized, just how many herniated discs he had in his neck and how bad it was for him. Because we had a good understanding of the low back, but the neck was kind of the sleeper injury in all of it that really drove up the physical component of it.
And so when you tried the case, and again, I don't mean to dip too deeply into the special sauce, but when you tried the case, what was, and I don't like the word theme, but what was the angle, the theme, what was the concept going into it?
Well, it changed because what most people don't know about this case is that there was a terminating sanctions order that was granted, I think 6 days before trial.
Oh.
So that was the bulk of all of this. Initially, when we prepped the case, it was a completely different case in the prep phase because you're planning for all of the other defense arguments, I guess. And then once we were able to strip that away because of the terminating sanctions, which I will probably get into in a little bit, we had 6 days to prep a whole new case. And that was probably the most exciting yet painful 6 days that I've experienced in a long, long time, because there's so many balls in the air all at the same time and trying to keep track of them. And you have to have a good team around you to be able to pull something like that off. And thankfully here, my dad and my mom have set that up so that I do. But yeah, so the theme initially going in was kind of, I don't even know if I remember it, because it was almost like I had to download it so I could get more information in for the 6 day period. But after that, it was really, there was Jesse Akiwa before, and there's not Jesse Akiwa anymore. And that was kind of what we drove all the way through because of that brain injury. We recognized we could drive the brain injury harder.
How much about the terminating sanctions can we talk about?
We talk about all of it.
Yeah. So I'm assuming it wasn't against you.
No, it was against them.
I would
on the verdict if it was against me.
Yeah. What, how did it, I think sometimes I go to a lot of different seminars and this and that, and it's all about, hey, eye contact during opening and questions during jury selection. And don't get me wrong, obviously, clearly I'm very interested in all of that. But goodness gracious, what evidence comes in and what evidence doesn't come in, so that's a big deal. How did this terminating sanctions happen? And what ultimately got terminated in terms of the evidence?
So it was an 8-month process.
Oh.
It took a long time. And it all started with, they didn't want to give us the cell phone records, which usually, usually that means there's something there. Smoke, there's fire kind of bit. And so we had filed a bunch of motions trying to get the cell phone records, kept trying to get the cell phone records, and they kept fighting it. And that kind of culminated with them saying, well, we're admitting liability, so there's no point in getting the cell phone records. Thankfully, we were able to get around that because there were so many issues with respect to whether or not my client lost consciousness, what the defendant actually saw, how fast she was going, things like that, where if she was on her cell phone, that would be testimony that would damage her credibility in that regard. And so we got an issue sanction on that originally, where there were some stipulated facts. It was, or not stipulated, ordered facts, where essentially my client lost consciousness and that the defendant didn't see the collision and could not testify to speeds, anything like that. That was the remedy that the court fashioned. But then from there, it just kept getting worse because we were debating not calling our client at trial And so what I wanted and what I was hoping for is that they would do sub rosa. And that's how I was going to present my client to the jury, was through their sub rosa. And I can't take full credit for that idea because I stole it from a good friend of mine, Matt Wibley, who is a fantastic lawyer over at Bardazarian's office. But then it turned into they wouldn't give us the sub rosa. And then from there, they kept refusing to give us things. And they just kept saying to the judge, well, fine, let's just do an issue sanction instead of terminating. And what had happened is they had sliced the trial so thin with all of these strange stipulated facts and all of these weird issue sanctions that the judge just kind of threw up her hands and said, enough is enough. And that's ultimately when she issued the terminating sanctions.
And what were the terminating sanctions, if I can ask that?
She struck their answer completely.
Oh,
they were allowed to show up, but they weren't allowed to participate.
Okay. Oh, okay. Wow. 6 days before trial.
Yeah, it was probably the most, if I could try a case anyway, it would be without defense attorneys every time.
Yeah, I would imagine. So, what was their, I mean, I know you're not the defense. What were they thinking?
I think they thought that there's no way this judge will issue terminating sanctions. And I think they thought they were going to ride that all the way to the bank. I thought what they wanted to do is they wanted to turn it into a battle of the experts and didn't want any other recipient testimony or evidence at all. Because every time we would go down that route, I think it was bad for them. And so they thought that she would just continue to slice everything so thin.
Wow, that is incredible. I didn't know that. What was it like when you got the terminating sanctions granted?
It was, so I've filed about 10 terminating sanctions motions over my career. It has been a career goal for me to get terminating sanctions, which is silly because they're so unbelievably hard to get. And so it all happened so fast. I didn't really expect it. I just assumed it was going to get denied again, you know? And so I remember I had an associate with me, and he was in the gallery and he was about to walk out because he had a deposition, and she grants it. And I just hear a briefcase drop. And he was so just shocked and excited about it all that he just lost control of his hand, I guess, and dropped his briefcase. And it was exciting. It was weird too, because it was this career goal I had just met and I didn't even expect it. And then it became a panic of, okay, you got to hold on to this. And so it was just, okay, I had to immediately snap out of that and become aware of, I've got a record. I need to protect my record. I need to listen to the judge and the defense and make certain I have a very good record for appeal at the end of the day.
Interesting. Great instincts, by the way, to switch right over to the appeal amidst such excitement. So you tried the case. Was it just a situation where you were presenting no opposing testimony, just the evidence that you portrayed?
Pretty much. Yeah.
I'm sorry. Go ahead.
We put on 4 experts and my client's wife. And that was it.
That's a unique pressure, actually. I mean, don't get me wrong. It's a good pressure, but it's unique pressure in the sense, because I noted you said, maybe asking for 120 or whatever it was too much. Yeah, of course you would want the defense not to present, of course. But once you get to that place, how do you convey and maximize the point with the jury? And I'm curious, what did you think?
Well, when that happened, my initial panic was, this is ours to lose.
Yeah,
especially when we asked for that big of a number. It was very much a, this is ours to lose. And that was a lot of the anxiety. The normal trial anxieties were gone. This was much more, I would say. It was, you would think it would be easier. It's not. It's much harder because you're so, I better not screw this up. And then even in the way in which that trial was run, it's so much faster. You know, you don't have time to collect yourself when the other side is up doing things. You don't have time to try to, evaluate. Like when you get done with your initial portion of jury selection, you can kind of sit down, and if you've got a co-counsel, be like, yo, how did that go? Where do you think we're going with this? There was none of that. it was, as soon as we were done, we were up for cause challenges. Then we were up for this. And then, I mean, it was just so fast, which was kind of nice in the same way because you didn't have time to think about that anxiety. All of that anxiety was in the beginning of this is ours to lose. But once we were in it, it was just, we were there to win. So.
You had said something about a juror who said something lawyers are greedy or something like that. Was that this case?
Yeah. Well, that was both cases. It was my last one and the one before that.
Oh, great. Why have one when you can have two? Did you strike that juror?
Yeah. So those jurors are actually, I mean, my dad taught me this too, is if you don't fight them, they'll strike themselves. If you don't try to cross-examine them, they'll strike themselves. So just accept it. Let them beat up on you. Let them just rip into you and do your best to hold in that sadness that you feel. At the end of the day, you are human, it doesn't feel good to have somebody say you're greedy. It doesn't feel good to have somebody say, there were a lot of other awful comments, to be honest with you, but you just kind of have to bear it, knowing that there's an end goal in mind.
Yeah. What an end goal it was. Did you, what's when you hit, and by the way, it wasn't exactly 120, it was more than that, right? At the end of the day?
Yeah, it was 126, 127, something like that.
Okay. What goes through your head when that happens?
Honestly, initially, nothing. You just blank out. Every time, I mean, when they read that verdict, there was just this gasp and this just, I don't know. And I don't know why, but I always get really emotional at verdicts. Because I feel like I pour everything I have into these trials, and it's like that weight being lifted is greater than anything. And it's not so much the number, it's so long as I beat the target number that I've built up in my own head. I think my response to it would have been the same if it was 20 million, 30 million, 40 million, 50 million. The number doesn't matter, but so long as my own target is met, I just have this wave of relief. But then after that, there's kind of this like, oh, wow. And then it turns into the same thing like the terminating sanctions. You immediately go on the defensive. Immediately, okay, we got, what do we do next? What's our next steps? You almost don't get much time to actually revel in the victory because you're you're so trained to immediately turn to the next steps in it.
Got it. Let me ask you, this is almost somewhat of a generic question. When you were doing whatever discovery that you did in this case, was there anything in particular you felt you had to get? And if so, why?
I thought I had to get the sub rosa.
Okay.
Because and here's why. On a mild traumatic brain injury case, it's very hard to put your client on the stand because as soon as they see them walking, talking, and looking normal in the first 20 minutes, which most mild traumatic brain injury people do seem normal, they immediately write it off. And so I needed that sub rosa if I was going to be able to portray the traumatic brain injury.
What is it so we are clear with the audience, what is it you were looking to get out of the sub rosa?
What I wanted was short snippets so that I could essentially focus on how terrible it was that they caused this brain injury, they caused all these physical injuries, and they're still following him around. And I had doctors who testified that, yeah, that would be terrible for him. You cannot take somebody who has all these emotional and cognitive symptoms stemming from a brain injury and then harass them with a bunch of investigators as they're following their family around, following their wife, their grandkids, things like that. And so I needed something to shift the focus of the case. I wanted to essentially take the traumatic brain injury, proving the traumatic brain injury, which was a tough thing for me to do, and change the focus and then reverse it.
Okay. So a couple questions here. Did your client ultimately not take the stand, or was the No, it was that a determination before or after the terminating sanctions?
It was an idea before and an ultimate determination after.
Okay. And then did you ultimately get that sub rosa in front of the jury after the terminating sanctions, or that sub rosa?
They never gave it.
Still
To this day, they haven't given it.
hasn't seen the light of day.
Yeah.
Were the adjusters in the courtroom during this?
So no, so there's a whole lot in this case, but they didn't even show up for the trial. They didn't. It was almost like they had written this case off as though it was still going to be whatever. It was going to be small, and it wasn't that big of a deal. And we later on, and this is a long story, and I'd prefer not to get into this just because there's so much behind it. But we later on got their valuation. They valued it at like $13,000 because they were dealing with, they didn't have all of the meds, and even the meds that they did have, they were cutting it so egregiously that they were treating it like it was worse than just a standard sprain strain.
Oh, geez.
And so, but yeah, no, there was nobody at trial. And then the first time we saw somebody was when the verdict was being read, and it was an independent adjuster that somebody had called at the last minute.
How did he look? She
didn't know what was going on. So she was like, oh, okay, they must have done a good job. See you later. We tried talking to her and she just had no clue.
I have a lot of training on the defense side, and as my friends have given me a very intimate insight into the interaction between the defense attorney and the adjuster. And you reminded me of that because they always tell me, like, Daniel, these adjusters are the very just like, yeah, okay. It's like a matter of fact, a matter of business almost. Was it that, but simultaneously, that's not a verdict I think any insurance company would scoff at. What do you think caused her to be so, well, yeah, okay, here we go?
I think what happened was they took an initial evaluation before, a lot of the treatment occurred, and they never moved off of it. They never adapted. Now, I do have to give this caveat because I think it's unfair for people to think that this was some masterminded thing. There's a lot of luck that went into this verdict, and I think everybody has to understand that. We were lucky, but to our credit, we were also ready to capitalize or to seize every opportunity. I think that you could have given a lot of these situations that we dealt with to a lot of other people, and they may not have gotten the same result. They may have even gotten better results. Maybe there were some things that we missed. But no, there was a lot of luck that got thrown in this. So I just want to give that caveat. Don't think that we're just some, as much as you've talked us up, don't think that we're just, that happens every day. Let's just put it that way.
Of course. I think in every endeavor, luck is like this weird thing where an opportunity comes along the timeline, and prior to it, you've invested in the skill sets to capitalize. Yeah. So, any up until you happen to just win the lotto and get the right numbers by no effort of your own, all luck seems to involve an effort and there's a labor behind them. At least in our career, everything in our career is laborious. So why not have luck be laborious as well, right? I think that's incredible. I appreciate your candor. I appreciate your humility. What is, in your opinion, and just from your experience, things that you've seen defense attorneys do that you were actually like, it's a good move?
I just saw this the other day. I've got a lot of people now that are asking me for what my numbers I'm going to ask for at trial. I think that's an interesting discovery set because it really shapes the case. But I think that a lot of times when defense attorneys fall on their sword with their bad doctors, there's very few that do for some reason. And I think that when they do, they actually gain a lot of credibility. I mean, if I've seen guys who can do it right, where they'll sacrifice a bad doctor for themselves so they can gain credibility. And I think if you do it right, it's a brilliant maneuver. because the jury's looking at you and they're like, okay, I understand that. And just knowing, it's when they concede the things that they should concede, and they do it in a way in which it's endearing, which is that's not a very specific way, and I probably should be a lot better at this. But when they do it in an endearing way, that's where I'm just like, oh man, you got me there. Because when I feel like I've got them by the short hairs and I'm about to pummel this expert into the ground, and I go and I sometimes I'll even call their experts and I'll do it first. When they just concede it and let it go, I look like a dick. And you just get so caught up in the fight of it that I almost always miss those. I mean, you got me again, damn it. So I don't know if that answered your question, but
it did, and it brings up two things in my mind. The first thing is there a reversal there? The other thing is I put these little notes up on my monitor here. Which one was? Two of them are your dad, actually, and it relates to what you just said, and it's something I took away from my podcast with your father. And he made a point. He said, he's like, I was debriefing, and everyone was like, oh, trial was going well up until you got angry and blew half the verdict. And that's so interesting, because how many plaintiffs' attorneys go up there and do get angry or sad? And my takeaway from my interview with your father was that he doesn't do that, or he does it through the witnesses and the experts. Correct me if I'm wrong, and then I'd love to hop into some questions about that.
Yeah, so he's of the opinion that anger and sadness don't drive up verdicts. And so when lawyers get up in closing arguments and they cry to the jury and they get all angry and things like that, that doesn't help them. We tend to disagree in some parts on that.
Okay.
He thinks he doesn't like it when the plaintiff shows a lot of emotion. And there's a lot of debate about this, and I've sat in on him debating other attorneys about this. I don't tend to agree with him on that. And I'm sure there's somewhere in the middle where we do meet. But yeah, I think that your client's emotions should reflect the scenarios that they're in. And that suspicion arises when the emotions don't match the situation. And so sometimes I think, and this is where we have discussions about this all the time. Sometimes I think when he says, and he simplifies it and says, you shouldn't show any emotion, that leads to the wrong impression. I think what he's trying to say, and maybe he's not, I probably shouldn't be speaking for him, but what he's trying to say is most people try to oversell it, and you shouldn't. But no, he interviewed, you probably know, he probably told you on his podcast, he interviewed Sapolsky, I think is who taught him that. Anyways, he interviewed some scientist who basically told him that, and that's where he's kind of run with it.
He did. He mentioned that this doctor didn't understand, or this researcher or PhD or whatever. He didn't mention the name, or maybe he didn't. I just don't remember. But he mentioned that this individual suggested that people don't like someone who's emoting with negative emotions in front of them, or something in that direction. Am I getting it right?
Yeah, and the science behind it is because it fires the mirror cells.
Yeah.
If you're angry, they're going to get angry, and angry people don't want to help people.
Okay. So if you have a jury that's angry, okay, you have a jury that's sad, okay. What do you want the jury? I know you don't have a magic wand where you can make the jury do whatever. Yeah, I get that. But for the sake of this being, this podcast is for lawyers. Lawyers are watching. We're trying to make our craft and our trade better. This is what our clients hire us to do. What would you want a jury to feel as you're doing opening, closing, whatever?
So opening is a little bit different. Opening, I just want an open jury. If I can get a jury that's actually going to listen to the evidence to begin with, I think we're halfway there. Because a lot of times, if you get a juror that's stuck in their own mindset about how this case has come out, you're never going to get anywhere. And that's why when you do jury selection, a lot of it is jury deselection, if not all of it is jury deselection. Getting off those jurors that have already made up their mind, regardless of what you say. And so I don't really believe you should have a lot of emotion in opening. I don't want them to feel much beyond just curiosity. I want them to kind of have a little bit of a lean as to where they think this is going. But I like to keep things very factual, very straight to the point, because it preserves our credibility. And ultimately, like in cases like the one we've been talking about, the more factual I am, the more factual the ask of $120 million seems. It's not, I'm not trying to play off of people's emotions, and I think it becomes more credible that way. Does that make sense? I mean, like the way I view it is that if you are the guy that just tells it like it is, straightforward, this is what it is. Jurors don't know how to calculate non-economic damages. And so they do have to trust the attorneys. And so if you're the facts guy, you're not the salesman, you're the guy that tells it like it is. Well, if $120 million is like it is, then that's what it is.
You may have just become another post-it note on my monitor.
Yes, that's what I was going for.
Credibility. Yeah, I try to put these things up here, remind myself of.
No, I think that's great. I'm not kidding. I think that's awesome that I'm going to make the monitor.
Appreciate it. Yeah, you look, and it ties in to not just things that I personally have kind of, I smelled in the air. I feel I probably don't have the grasp of it that you guys do, but I sense it. And then I hear you say it. I hear your father say it. Reputation, credibility, how you were perceived. Because you're right. Most people aren't going to know. I mean, really, how do you quantify any? Hey, my arm got amputated. What is that worth? I mean,
I don't know. I can't figure it out. I mean, I have, when I think about it, what I would accept, but usually when I think about it, there is no amount of money. And so that's why for jurors, it's the same thing. You know, nobody knows what an arm is worth. There's no value that you can really assign to that, but that's all we've got. So if you're the guy that they can trust to tell you what an arm's worth, then they're going to trust you.
Exactly. The credibility sounds like it's really critical there. And we'll finish up with this because you've been very kind with your time. We've been going an hour. It doesn't feel like it, but we have.
Oh, wow.
Yeah, right. It doesn't feel like it. Yeah. The defense attorney was throwing his bad expert off the ship to maintain the credibility of the ship, to maintain the reputation or whatever it might be. I had the conversation with you about how your father, I'll just read you what it says. I want jurors to feel safe in my corner, not afraid or angry. Calm is strong. Show them warmth and safety. Those are the two post-it notes I took away from your father's interview. And it almost sounds like how you describe that defense attorney who was getting rid of the bad experts. It almost sounds along the lines of, I want jurors to feel safe in my corner. I want to show them warmth and safety. Is there a connection that can be made there, or am I just coming out of nowhere?
No, I think you're dead. I think you're dead on with that. I mean, I think falling on your sword is one of the most endearing and trusting ways, or I guess ways that you can inspire trust with people. Like I feel safe around somebody who's going to be open and honest about their shortcomings, and they'll apologize for it. And I feel comfortable around them because I feel safe that they're not going to try to screw me without me knowing about it, right? And so when you have that with jurors, I mean, I think that's kind of why I think that defense attorney tactic that I talked about made sense, and why I think it works. I've never actually thought about why it works, but I think that I remember I had one defense attorney who I called his expert and I just destroyed him on the stand. He didn't even ask any questions. And then in closing, he got up and he goes, I didn't even call him because he was wrong. I don't disagree with you. He's wrong. He's absolutely wrong. And it'd be wrong of me to try to present that to you. And I just remember thinking, I am just a piece of and I'm just an awful person. And I think the jury kind of looked at me like,
oh no,
why would you present this wrong information to us? And I felt bad. I felt like the jury didn't trust me because of it, and they trusted the attorney because of it. So they felt safer with him.
Final question. With something like that, is there a reversal? Is there a response?
When he did it to me, is that what you're talking about?
Yes.
I couldn't come up with one then, and I haven't come up with one since.
That's an honest answer for a man who clearly, you got some big numbers, and I know the 120 is not the only one. Clearly a guy who knows what he's talking about in this arena. Clearly a guy who comes, you guys are going to be like a family lineage of like excellent trial attorneys. It's an interesting thing to me. I appreciate you taking the time, my friend. I appreciate you coming on here. I was really looking forward to this one. I didn't prepare a script because I just wanted to just talk, not a script, but an outline, because I wanted to just talk, and I'm happy it went that way. I didn't know if I was going to share my Post-its on the monitor, but that's out there now. I always like to ask, is there any final word you might have before we close this one down?
Yeah, if I were to say anything, I mean, just if you're directing this towards the audience, that I could say, try cases, try them now, try as many as you can. Now is the time to do it. It's crazy out there. This is the best time to try cases. I know COVID's weird and it makes it a little bit more challenging, but jurors are finally understanding what pain and depression and sadness and loneliness is. And the script has flipped. You're no longer in my line, greedy ambulance chaser, and you're actually a defender of the weak. And it's very, very, very rewarding. I hope that encourages somebody, because it is so much fun right now.
Amazing. Mr. Khail Parris, thank you so much for your time. We appreciate it.
Thanks for having me. This was a lot of fun. I can't believe it's been an hour already.